Good afternoon. My name is Raymond Pepe. I'm a commissioner from Pennsylvania. I've been on the Uniform Law Commission since 1983, and I'm a lawyer in private practice with a law firm called K&L Gates, and I have the privilege of chairing this Federalism Committee. The function of this panel is to discuss the draft principles of federalism that the committee has developed over the last couple of years, and to discuss how to better garner attention to these principles and how to use these principles to improve the balance of federal and state law. Our panel today consists of Chris Cushing and Judge Gregory Mize. Chris, many of you know, is the managing director of the Nelson Mullins Public Strategies Group, a longtime lobbyist here in Washington representing a fascinating variety of public sector and private sector clients. He was previously the director of governmental affairs for the Wolf Block law firm out of Philadelphia. He also previously served as the principal legal advisor to U.S. Senate Majority Leader Bob Dole between 1985 and 1988. He brings a variety of great insights to the conference and has served us very ably. Judge Mize is a judicial fellow at the Center for the State Courts, works on a variety of projects, including jury studies, as well as a variety of other special projects, including a task force on foreign lawyers and international practice. In particular, Judge Mize monitors congressional legislative proposals that jeopardize federalism principles. He was appointed by President Bush to sit on the Superior Court of the District of Columbia, which he did for many years until he assumed senior judge status. He also previously served, before going on the bench, as a trial lawyer and later as general counsel for the District of Columbia. Let me kick this discussion off by doing a brief and quick summary of the principles of federalism that we have developed to set the stage for our discussion. Our principles start with the proposition that the manner in which our federal Constitution is prepared, which reserves to the state all powers not delegated to the federal government, denied to the states, are necessary and proper for the exercise of federal power, are reserved to the states, and that by doing that, it serves several very vital interests. The founding fathers, of course, were concerned about the preservation of liberty, but there are a variety of other, much more contemporary needs that division of power serves. It respects and preserves the diversity of cultures, resources, and needs in our various communities. It allows states to serve as laboratories of democracy to promote experimentation and the development of new programs. It promotes governmental cooperation, both between the federal government and the state governments, between the states and between states and local governments. And it gives citizens a much greater stake in the political decision-making process by keeping power close to home. Having said that, however, because the same types of objectives that can be pursued under the state police power can also be pursued in the exercise of delegated federal responsibilities in many areas, most notably in the area of the regulation of interstate commerce. Inevitably, there's going to be conflict. And if this conflict is not managed carefully, it can cause some significant harms. The conflict between federal and state law, if not managed carefully, can create a tremendous amount of uncertainty, which just makes doing business very difficult for people that are trying to operate, in a regional or national basis. That increases transactional costs and impairs economic development. It creates the lack of careful, delineation of federal and state responsibilities creates endless amounts of socially almost worthless litigation, which keeps many lawyers like myself, quite engaged. But at the end of the day, it does little or nothing for the public. It creates a confusion and uncertainty about the jurisdiction of state and federal courts. It can overtax the burdens of the federal judiciary by requiring them to consider issues that are far better left to state courts. The amount of time that the typical federal judge these days will spend on criminal prosecutions that historically would have been left to the states, is a shame. It's also very challenging for federal courts to resolve issues of state law that are inevitably arise, when federal questions are presented to federal courts. I mean, the federal judges are called upon to interpret state law that they might not be well equipped to interpret, or, on the alternative, certify matters back to the state courts for an appropriate interpretation, which just slows everything down. The lack of a proper division of responsibility between the federal government and the states also can overtax the responsibilities of federal agencies and call upon federal agencies to administer programs for which they don't have the resources and they don't have the contacts with the communities. Finally, I think an inadequate, careful delineation of federal and state responsibilities does somewhat erode our democracy by creating a sense of top-down governance rather than governance from the bottom up. Having said all that, the solution to having a better balance, is not something we can primarily turn to the courts to. The best the courts can do is define the outer limits of federal responsibility, and they have to defer to the judgment of legislators to determine what constitutes an appropriate exercise of federal power. What that means is that the solution lies in the political process, and it lies with the states and the federal government. So what we've tried to do with the principles of federalism is to try to offer some thoughts that we believe are helpful about what is the proper role of the federal government, what is the proper role of the state government, and what ought the private sector to do to contribute to this process. With respect to Congress and federal agencies, what we call upon our principles to do is to make a number of suggestions as to how federal agencies and Congress ought to, in theory, act when undertaking new initiatives that might affect state law. And it starts with the proposition that it's critical to know the current nature of state law and understand the effectiveness or ineffectiveness of state law, and whether state law is currently addressing an existing problem before undertaking a new initiative. It requires a careful understanding of the differing needs, circumstances, and requirements of the various states. It requires a careful identification of the range of options for dividing up federal responsibilities, and those options might range from simply providing advice and recommendations to the states, providing funding or incentives for the states to adopt new laws and regulations. It might then involve adopting minimum standards that all states must comply with, or it might involve outright field preemption. And we have to understand that in the context of promoting interstate commerce, field preemption is often needed and necessary, and it has helped bind us together as a country. But all of those options have to be identified, and then for a particular policy initiative, the option identified that is most cost effective. And in doing that, it's regardless of the extent of federal preemption, it's important to develop institutions and policies that promote cooperation between the federal and the state government. We were also recommending that state law should be preempted only to achieve important national objectives that can't be otherwise reasonably achieved. And in that regard, it's important to exercise great restraint when legislating or regulating in areas of traditional state responsibility, or in areas in which the states have developed uniform laws or are developing uniform laws. And in particular, great care ought to be taken in federal regulation that affects private rights of action, especially under state tort law. Finally, it's critical to be very attuned to the effect on federal actions on state spending and whether or not it creates unfunded mandates. Having said that, the responsibilities do not all lie under our principles with the federal government. They also lie with the states. The states have a significant role to play in the federal division of responsibilities. States have an obligation to address emerging problems of regional and national significance. Far too often in the past, states have given up their powers and Congress has taken over an area because states have simply failed to act. So states need to step up and deal with emerging problems. States also need to avoid creating conditions which lead to federal preemption by adopting laws, for example, that impede or interfere with interstate commerce. It's also critically important for states to actively participate in the development of federal law and in the federal regulatory and legislative process, and provide strong support and funding for their institutions, such as the National Governors Association, the NCSL, the Center for the State Courts, and other organizations that represent the interests of the states. And finally, it's incumbent on the states to undertake efforts to develop public and private partnerships with groups like the bar to encourage the development of law, especially in areas that are traditionally the areas of the common law. Finally, our principles identify a few important responsibilities for the private sector, the most important of those of which is to educate their members on the importance of federalism and to try to take a principled approach to advocacy. And rather than choosing the approach that is most effective to adopt the goal of a particular group at a particular time, at least give some careful consideration to the federal scheme. Now, in developing all of these principles, we've also tried to identify circumstances in which we think it's more important to try to preserve state law or more important to give primacy to federal law or allow federal law to preempt. And in that regard, we've tried to identify some standards and criteria in that regard. For example, we've suggested that federal law should substantially control an area when the exercise of enumerated federal responsibility demands that a problem be addressed uniformly. When prompt action is taken, needed to solve a problem, and we can't wait for the state legislatures to address it. When there's a high degree of need for uniformity to promote economic growth and development, when interstate competition may just encourage a race to the bottom, and when federal law has been principally primary in area. In those areas, it would be appropriate for the federal government to substantially control an area or perhaps exercise field preemption. On the other hand, state law ought to be respected in primary and have primary responsibility in an area where there's a reasonably likelihood that states can develop reasonably uniform solutions to emerging problems. When there is room for local variation and there is not a need for locked state uniformity, when federal preemption would impose unfunded obligations on the states that would be difficult for them to meet, when the process of developing laws from the bottom up at the state level is useful in developing a high degree of political consensus, and when the time and cost required to develop a uniform approach to a national problem through state law is justified in terms of the outcome. And finally, where state law has historically been primary in an area, we believe the Congress and federal agencies should be very reluctant to tread. We spend much time today, bemoaning the lack of respect for state law and the ever, growing scope of federal law, but we also have to step back and continue to recognize that very substantial portions of our laws in this country continue to be state laws and will continue to be state laws. Obviously contract law, torts, criminal law, education, insurance, estates, trusts, domestic relations, land use planning, workers' compensation, unemployment compensation, just to name a few, are all predominantly areas of state law. State law will continue to be important. So at this point, I would like to turn to our panel and see what their thoughts are about whether these principles, as I've articulated them, are a useful approach to describing a better way to integrate federal and state law, and more importantly, how we can take these general principles and operationalize them in a manner and promote their use in a manner that might make a difference in terms of how Congress and federal agencies define the relationship between state and federal law in the future.
Thank you, Ray, and it's good to be with all of you. Given our abbreviated time availability, I'm going to try and move very concisely. And I thought the way I would bring some practicality to these principles is to tell you about we could call it a clinical case study, as I tried to talk about federalism principles with some members of the legal staff in the Senate Foreign Relations Committee recently. Now think about that. What would federalism, state, federal, shared responsibility, how would that fit with foreign relations? Well, I'll get to that, but to tee it up a bit, those meetings that Kay Farley, who's the director of the Government Relations Office for the National Center for State Courts, and I had last month, so it's pretty recent. And what sets this up is the National Center for State Courts, as the secretariat to the Conference of Chief Justices, is concerned about federalism issues, of course, and I have been following the course of events are really around the world as the legal profession is being regulated in varying ways across the globe as legal business becomes transnational. So what's happening in Australia, the UK, Germany, South Africa, very different rules of conduct, enforcement mechanisms, and of course, state Supreme Courts are responsible for setting the practice standards and the discipline systems for lawyers admitted in their states. So I'm looking at that picture for the Conference of Chief Justices. And then there is the clinical case study that I cannot imagine is more complex that the Uniform Law Commission has been involved in, and that is implementing the Hague Convention on Choice of Court Agreements, which the United States signed in 2009, but which needs implementation. And the State Department, calling upon the Uniform Law Commission, thought it might be possible to have a cooperative federalism approach to implement this treaty. The treaty basically sets up a mechanism that's analogous to the New York Convention for Enforcement of Arbitration Awards, but this would be on the litigation side, court related. And it basically sets up a network where in commercial contracts, sophisticated parties can choose a court that would resolve any disputes under their commercial contract. And the treaty would make sure that a court chosen would take the case, a court not chosen would decline the case, and any judgment coming out of the chosen court would be enforceable in other treaty partner jurisdictions. And over a 3-year period, trying to create a cooperative federalism approach, there was, for 2/3 or 75% of a 3-year period, a seeming commitment by the State Department and the federal government to have a cooperative federalism approach whereby there would be 2 statutes or 2 legislative schemes that implemented the treaty, one enacted by Congress and the other by the states resorting to a uniform law drafted and now approved by the Uniform Law Commission. And they were basically designed to be identical, the draft federal legislation and the Uniform Act. However, late in the 3-year process, actually April of last year, about a year ago, after meetings that have occurred with international lawyer groups, concerned stakeholders at the State Department, all sorts of meetings in different fora, and a seeming agreement among the Conference of Chief Justices, the United States Judicial Conference. It seemed like everybody had signed off on these two-track approaches. And then the State Department decided that, oh, well, we looked at it more closely, and we think there's a problem if a case is in federal court and the state in which the federal court is located has adopted the Uniform Act. Does the federal court apply federal law or state uniform law? Everybody to this point thought it would be, following typical Erie doctrine, it would be the state law that applies. No, the State Department said we should have a provision in the federal statute that says in a situation where there's a case in federal court in a state where there is the Uniform Act adopted, the federal court would apply federal law. Everything unraveled, everything fell apart. And things are on ice. I don't know where it's going to go with the new leadership in the State Department. But for the first time ever, now you can see how maybe Senate Foreign Relations Committee might be involved in a federalism issue, is Kay and I thought would be good to talk to the legal staff of the Foreign Relations Committee to describe this situation, the saga of the choice of court agreements, and to also talk about how trade agreements, which can go through that committee, how trade agreements can regulate services, and including legal services, and maybe regulate the practice of lawyers to make these legal services more easily provided over treaty partners in trade agreements. So I'm sitting down with very, very bright lawyers, and I mentioned Erie versus Tompkins, and one of them says, "On Erie issue, I haven't thought about that in years." Oh, that's very fascinating. And all of the lawyers said, wow, we would have never known that there are these state issues that arise. Thank you very much for bringing this to our attention. We're going to stay in contact. Now, back to the principles. I look at the last page of the two-page, four-sided summary that you have of the draft principles. And the matrix on the back page is a nice, concise set of ways to think, well, is this something that should probably be federal, more likely be state, or is it a hybrid? It's a close call, which is the middle column. And as I was preparing for this session, and I'll close with this, I looked at these principles and I said, well, what if I had these in hand when I was meeting with these very bright lawyers in the Senate, a majority and minority staff? It was two sets of meetings because of course, the way Congress is right now. You meet with the one side and then you meet with the other side. And I'm perplexed. How is this helpful? Unless they read it, unless a senator gets to appreciate it, unless at a public hearing maybe a chief justice or a governor talks about it, I'm not sure it's going to go anywhere. These are fantastic principles. It's really something worth, it really is an educational tool, and I think that's what the ULC had in mind. But I think we need to spend some time, and maybe the next panel and maybe tomorrow will be devoted. Who are the messengers for this? How does it get used to really educate in a effective way so that when there's a rush to do something, people stop? This seems to be something that requires an evidence-based approach, taking the time and examining what are the facts. I'm not sure we're in a situation where that's a very popular approach. I'll stop there.
Good afternoon. Thank you very much for having me here. And Ray, thank you very much for the kind introduction. Despite the promotion you gave me, I was not a legal advisor to Bob Dole. I was a political advisor. And as a matter of fact, I'm not a lawyer. So if I misspeak about law, I'm not a bad lawyer. I'm just uneducated. The second thing also is, being the last speaker and the second to last panel, it can be a case of everything's been said, but not everyone has said it. And I hope it won't be that way. So I don't have prepared remarks. I've tried to pull together some of the things that I've been hearing from the different speakers today, and hopefully these thoughts might be helpful for you both today and tomorrow as you consider the principles. And please feel free, because we're a little short on time, I know. If you have a question as I'm speaking, I won't be offended if you ask it, as long as you're not like Joe Wilson and say you lie at the State of the Union address. I think these principles are useful, and I think we saw a little bit of that today. David Agnew told me privately, and I think we heard publicly from the Senator and Governor Markell, that they read them before coming here. It's nice that we now have one of 50 governors, and we have one of 100 senators, and one of 3,000 presidential appointees. So we're making some progress, but we have a ways to go. But I do think it's good for a rallying point. It's good to get things on paper. And the most important thing I think to think about is the different look of what is federalism. I was reminded of the story of the blind men touching the elephant. One is touching the tusk, and it's very smooth. The other is touching the hide, and it's very rough. You had Governor Markell talk about cooperative federalism. You had David Agnew talk about intergovernmental cooperation. At the same time, the senator talked about federal overreach and a legitimate concern of that, and I think you heard that from Senator Risch also. We have to realize both are valid, and I think they both have to be in whatever principles are in here. But that's two different looks. One is almost an adversarial, or as the court said in NFIB versus Sebelius, a check on federal power. That's what federalism. The other is that we need to cooperatively deliver services to our shared constituents, which is what Governor Markell said. I personally think that these principles do a good job of balancing that, but I wanted to draw that to your attention. I think that's important. And the reason I think they do a good job is we talk about the efficient integration of federal and state responsibilities. And with responsibilities, also we speak to rights, and I think we do a good job with that. I think, and Ray, you talked a little bit about this too, we have to realize that there are some inherent problems with federalism. It's not 100% necessarily good. One is it can impose significant barriers on and cost on commerce. One of my clients is Google, and were complaining to me the other day about the 45 different data breach laws that they have to deal with, or Amazon has to deal with, or eBay across the states. That's a real problem. It's going to be very interesting, I think, to see how the internet drives or does not drive preemption or federalism or uniform law. I leave that to you. The other thing we heard about is it's tough to get the public engaged on this. Governor Markell talked about the fact that the lines are blurred among local, state, and federal responsibility to a constituent. They just need something done or something to happen. And also, and this was also in NFIB versus Sebelius, that federalism is just not as compelling as the Bill of Rights or the 14th Amendment. And then the third thing I think we have to think about when trying to engage the public, if we can, is that federalism is usually a secondary factor. Everyone loves federalism, but it's usually a secondary factor to ideology. If you happen to like who is president, you're happy with what that president is doing, even if both parties are hypocritical when it comes to federalism, whether it's a Republican president talking about Medicare Part D or No Child Left Behind, or it's Democrats telling us what the toilets need to be in our homes, what the light bulbs need to be in our homes. And that's something I think we have to do. And as people alluded to, as David talked about, maybe you can get governors and mayors or former county officials like you have with Chris Coons in Delaware together. People, when you're outside of DC, you talk about you want to drain the swamp. When you come here, you're like, boy, this is much more like a hot tub, I think, than a swamp. I'm really kind of getting into being here. And the final thing, not to minimize, we're talking back to people. I know we have scholars here who've been studying, 18th century, I guess, law. Nowhere could our founders have thought about what a populist presidency we're going to have. They would be unable to understand how the President of the United States could be in every person's home every day. And that really, I think, is a factor that I don't know how we overcome, but drives more preemption. But there are some opportunities, I think, for federalism. The one we heard about from both the senator and David Agnew, they agreed on, is the partisan gridlock here in Washington. And usually I found, I've practiced at all levels of government, things are less partisan as you go down the scale. As LaGuardia said, there's no Democrat or Republican way to fill a pothole. I think that's true. And maybe the public is going to see that as a virtue. The second thing is scarce dollars. We've been talking about unfunded mandates and government mandates. I think, perversely, scarce dollars may drive more experimentation at the states, or may drive a greater interest in federalism, and we should think about that. Both parties, Pew just came out with a poll, interestingly, today. I just got on my BlackBerry. Both parties believe that federal government's too big and tries to do too many things. They come at it from different angles, whether it's the government. I gave the senator credit for admitting he's okay with saying he's totally in favor of DOMA, but he's not really in favor of the federal government preempting states' rights. But whatever, right or left, people think the government does too much. And Pew came out today with interesting figures. 63% of people approve of their local government, 57% approve of their state government, and 28% approve of their federal government. That's an update on last year's poll, where the feds have now dropped five points. And interesting today also, Chairman Schuster of the Transportation Committee in the House came out today and said the feds were doing too much in transportation, that we need innovation in transportation. We need public-private partnerships, which 2/3 of the states have. And the feds need, in some ways, get out of some of the regulatory aspects of transportation to do that. So I think we have some opportunities there. The final thing about these principles we need to think about is education. The court, in its dissent on the Affordable Care Act, talked about the responsibility of the court to educate the public about federalism and an appropriate balance of federal-state relations. George Will did a column, I guess, about 4 or 5 months ago on this, and said, how do we rekindle the public interest in federalism? That's really what one of our challenges is. Part of it maybe we can do here in Washington by working with Congress or the White House and talking about the ACIR or others. But I do think we have to think about on these principles as you look at them, is there an educational element that we can have? So that's one side that these principles have to do, is educate lawmakers or policymakers, but if we can, how do we get this into the public domain? The other thing about the principles, and I think it goes back to what you were talking about in your time with the Senate, is will these lead to better laws and regulations? Will these avoid bad acts? We heard about the Adam Walsh Act, which had probably noble intentions, but is not doing what it's supposed to do. Famously, we had Real ID. The idea is, do you want it done right or do you want it done fast? People thinking that at least federal preemption is fast. It may not be right, but at least it's fast. The Real ID Act hasn't done anything to improve our safety. It hasn't done anything to create interoperability of licenses, because the states have said we don't have the money to do it, we don't have the interest to do it, and about 1/3 of the states, the state legislatures, I don't know if you did in Alaska, passed laws that said we will not abide by the Real ID Act. So I think we have to think on this, will these result in better laws? And the final thing I think we need to think about too, and it's been brought up by several of the speakers, and now Professor Sharkey talked about it, and I think David Agnew did. Will it also lead to better regulations? I think in the principles we're thinking how they draft laws, but I think one of the things, at least I learned today, and I think we heard today, is it's equally important to look at how these regulations are drafted and how these regulations are implemented. And do these principles speak to that, or should we expand them for that? So that's my thought on this. I wish I frankly had an answer of how you can engage the public on federalism. I'd give it to you, and I'd probably go to Madison Avenue and begin a great career on selling stuff to people that's very complicated and they don't know they even need. And I say that with a little bit of humor, but it's something we really do need to think about, is how we engage on that. So Ray, I think I'll turn it back to you as our moderator and take questions.
Questions? Please.
Jim Maxon, University of Baltimore. I'd just like to ask how you've gone about your work. I've heard all these problems today, not so many solutions, but we're not the only place in the world that's thinking about these things right now. The European Union is confronting them every day. In the last 10 years, Germany's had a huge reform of federalism. Did the commission consider ideas from abroad?
Not at this point.
I encourage you to do that.
Do you have good ideas to suggest? We're really open to suggestions.
I'm here to work on my book on that. I already have one on litigation, so.
So we have to wait to buy the book to get the answers.
Yeah, it is fascinating. One of the themes that came through the discussion earlier today is that so much of the problems of federalism are driven by money. I mean, Congress controls the purse. They provide, tremendous amounts of funds to the states, and with those funds come conditions. And, if you're going to have a central government driving the money, is it reasonable to expect that it won't come with conditions? And in that regard, it makes you think about England and Scotland, where Scotland gets tremendous economic benefits from England. But on the other hand, the Scottish Parliament, as I understand it, largely has home rule.
And that's actually bringing up on the dollar an interesting question, which I presume may need to be resolved in the courts. And again, I'm not on lawyers, but so anyone correct me if I'm wrong. But what was interesting in the decision with the Affordable Care Act is they went back to South Dakota versus Dole, which spoke to holding back a portion of transportation funding relative to drinking laws or seatbelt laws. And the court had said that is fine. Transportation funding is a relatively small part of overall federal, relatively small part of a state's budget, and they were talking a small slice. Justice Roberts said that in regard to Medicaid and the subsidies in Medicaid, that this was actually a gun to the state's head. So we have a wide gap here of where does coercion come in? Holding back 5% of federal government transportation dollars, or what they're trying to do with Medicaid, and that needs to be resolved. We still don't have an answer, I don't believe, to that question.
So when I read these principles, I thought they were so abstract that a conservative and a liberal could agree on them and then disagree on every single application of them. And I thought in defense of Senator Ridge, one reason he said, I voted for DOMA even though I thought it was unconstitutional, is he said, because the other side's doing the same thing. And so it seems to me that maybe what you guys need to have are cross-aisle horse trades, where the federalism, take immigration. Conservatives tend to dislike sanctuary cities. And so they're preempting, and they try to preempt, sanctuary cities by saying local law enforcement have to cooperate with the feds, or at least the local law enforcement chiefs have to let them cooperate with the feds. And meanwhile, liberals don't like state officials who deny driver's licenses or university seats to undocumented aliens. So those are two cases where both sides agree on their version of federalism. It seems you're going to have to bundle them together to get an overall defense of federalism. Where states have the right to resist DACA, Obama's DACA immigration policies, and states also have the right to resist immigration officials on sanctuary cities, or cities have the right to maintain sanctuary cities. Are you thinking of forming those horse trades? Because it seems to me, unless you form those horse trades on specific issues, everybody's going to say, I'm for federalism, but I'm waiting for the other guy to support federalism. I'm not going to vote against DOMA unless the other side votes against Roe v. Wade, which is essentially what the senator said.
Now, if you want to take that on the principles. Well, I was just going to say, I think it's difficult for two reasons. One is, at least they're both parties extremely consistent, as I said, in their hypocrisy. So that may give us an opportunity. The difficulty is, they always say, laws are like sausages. You really don't want to see them made. I don't really see any horse trading going along by saying, I'm going to take my hypocrisy about someone's right to get married. I'll trade it for your hypocrisy about a church's ability or someone's ability to provide sanctuary to someone you feel has broken the law. The other thing, too, is I don't think we can minimize the degree of partisanship. And actually, coming out of the National Governors Association meeting in February, every February in Washington, healthcare has really even made the governors more partisan. They weren't that way, and the Republican governors had put together what they thought were some very basic Medicaid reforms, and they threw out all the things that were controversial. They put it on a piece of paper titled Medicaid Reforms, and they presented it to Martin O'Malley, the governor of Maryland, for his consideration. He said, we can't do this. If you have the word reform in here, it implies there's something wrong with Medicaid, and I won't even discuss anything that speaks to reform. And it's just that partisan. You can't admit that something could be better, or somebody did, or the president did something good. I mean, it's both sides. It's going to make the horse trading difficult.
Let me just offer one other thought. I think that to the extent that Congress and federal regulators think about these principles carefully and think about the importance of federalism when they regulate or legislate, we're going to get better laws or better regulations. And I think the examples where things have worked very poorly is where Congress or regulators simply didn't think about the problem. I mean, classic is ERISA preemption of health plans. I mean, there is no indication whatsoever that Congress had any thought about the broad scope of ERISA preemption. And while, these principles on their face, might look like motherhood and apple pie, had Congress gone through that exercise and thought carefully about the meaning of those words they were putting in ERISA, we may have had a better outcome and avoided dozens and dozens of appellate court decisions about the scope of ERISA preemption.
I can't resist an observation, and that is that I think we understand that it'll be very useful to get congressmen who are politicians to think very hard about these principles and do a better job. But if we look at what's really happening, partisanship is ruling the day, and that makes it very difficult to think we'll persuade many senators and many congressmen to do what it is that you'd like to have them do, or we'd like to have them do. I think we should keep trying. But I think their gridlock provides an opportunity. It's one I think Chris mentioned, and that is if Congress can't be effective, and state law can prove that it can be effective, there's real hope for federalism in that respect.
And I just say too, I'm not giving comments to a client, but it really is true. You all are a great example. You represent states large and small, east and west, north and south, urban, rural, on some really tough issues that relate to who's going to get a child or other issues that are as basic to human rights and living. And you guys do it annually. You've done it for over a century, and you do it darn well. And maybe somewhere in there, you can be a bright spot to say there's no reason Congress should be as dysfunctional as they are, because you all are in some ways a mirror image of what they and what you represent. So I think there's some opportunity here for the ULC.
And at this point, I think we need to turn it over to the next panel because we're running a bit late.